Appreciate everybody taking the time out in their afternoon and participating in our webinar. The topic today is about employee substance abuse and drug testing. So we're going to talk about what the unemployment office is looking for in regards to misconduct pertaining to employee substance abuse. This used to be pretty much a clear-cut issue. Of course, in the past few years, as we're all aware, this has been complicated a little bit by the introduction of legalized medicinal and recreational marijuana. That's one of the things that's kind of complicated this in some cases. But generally speaking, what all the states have applied is that if your work policies specify that an individual can't be on either of those two things, that still constitutes misconduct. So, but let's just talk a little bit about when you can test. Misconduct is defined basically as the use or impairment caused by an alcoholic beverage or a controlled substance. And that's prescribed or illegal. Just because you have a prescription for a particular type of medication or narcotic, i.e. pain medication, that does not mean that gives you the right to appear to work under the influence of that would impact and obviously would have an impact and effect on the safety of the employees or their condition of the working environment. So it can be a prescription drug as well. The drug test must be conducted by a federally certified lab. That means you have to prove that the laboratory that is conducting the testing of the sample is federally licensed and certified and is meeting all the federal requirements required of them to operate a drug testing laboratory that would keep all the chain of custody done, the samples, so on and so forth. So they got to show that that they're within the protocols and requirements of the federal government in regards to conducting drug testing. The form of drug testing that all the states allow, obviously most common one is urinalysis, but it can also be blood, saliva, or a breath test. Breath test is conducted usually by some kind of law enforcement official, but we do see them conducted at medical labs as well. Saliva is one of the ones that is really the one that you don't see very often anywhere anymore because they haven't been proven to be very reliable and certainly not as reliable as urinalysis or blood or breath. So, but some states still allow that to be a source to use for establishing misconduct. You must show that the chain of custody was carried out in the appropriate manner. That means the chain of custody of the sample taken by the individual who is the appropriate individual, and then that chain of custody shows that the sample was handled correctly. It wasn't contaminated in any way, shape, or form, and that it made it all the way to the medical review officer for final analysis and sign off of whether or not it was a positive or negative test. Generally speaking, the sample must be collected by a licensed healthcare professional. The caveat to that, obviously, that I mentioned earlier is that if it's a breathalyzer test, it can be conducted by an individual who is certified in that particular area and/or that individual is a police officer trained in the proper use of the breathalyzer. But generally speaking, it adds weight to your argument and it eliminates an excuse by the claimant if the sample is collected by a licensed healthcare professional. Hair testing can be, I just saw the question in there and I'll just go ahead and answer it while we're on this topic. Hair testing can be, yes. Generally speaking, again, that's one of the things we rarely see in that type of thing, but yes, hair testing can be, and I've seen it used to establish misconduct. Another interesting thing while we're on that, because where I've seen the hair tests conducted more frequently is proving whether or not the individual is in violation of a non-nicotine, anti-nicotine, anti-smoking policy, particularly if it's an individual who has established up front for insurance purposes that they have that they're a non-smoker, and then there's proof that they are a non-smoker, that they are a smoker. So we've seen that often in that kind of area, not so much in the other areas of testing for whatever reason. Now, the test can be conducted for probable cause, which is called reasonable suspicion. We're going to talk a lot more about that here in a minute. It can also be requested or required if the employee is notified at the time of hire that it's a condition of employment. For example, random testing, DOT, for example. Other areas might require random testing, post-accident testing, and then, of course, a testing that's required by an employee assistance program. Oftentimes, when you enter into an employee assistance program to substance abuse, one of the prerequisites is that they can be randomly tested at any time for a period of time. One of the things that I want to make sure that you understand is that pre-employment drug testing means pre-employment. If you put the individual to work prior to receiving the pre-employment drug test, it is very likely not going to be misconduct because the state says basically pre-employment means pre-employment. Now, the good news about that is that in those circumstances, the unemployment claim is almost certainly to be a zero liability claim, so it wouldn't have an impact on your rate as it is, but they will not, about 99% of the time, they're going to say you took on the burden and the risk and liability of putting that person to work before you got the test, so it's not going to be misconduct in most cases. In nearly every state, refusal to take a test is covered by law, okay, and policy as good as a positive test. So if you have a legitimate reason covered under your policy, under the law, to test that individual, and they refuse to take that test, then that almost 99.9% of the time is going to result in is a disqualification for, they view it as good as a positive test. So keep that in mind. But the caveat to that is that you can't just say, allude to the fact that you may is going to test them or something along those lines. You have to be specifically saying you will go to the testing, the sample site, you're going to provide a sample, and you're going to be tested, and here's the reason why. And then when they refuse, make sure you document that, put that in very clear writing that they were told that this was going to be a condition of continued employment, and their refusal to test is going to result in their termination as you view it as their admittance, admitting that they are basically under the influence. So make sure that you don't just stop right there and say, we're not, you're refusing the test. Make sure that you clearly identify to them that this is going to have an impact on their employment if they do not test. Okay. So now going along, what are the pitfalls and the common issues that we see over the years about drug testing? What has fouled them up? And I would say easily 95 to 98% of the time, a drug test claim results in a disqualification. Where we see the issues where it doesn't result in a disqualification is first and foremost policy. Okay, the policy does not cover the reason for the test. If your policy does not identify that post-accident testing is going to be a requirement and you try to post-accident test an individual, the state will throw that out because the individual, regardless of how common sense that may be, they are going to say that individual did not know under policy that that was going to be a requirement of them, okay? So you want to make sure that you review the policy and you make sure that everything is identified clearly as to when and how you're going to test that individual, okay? Also, the policy or the protocol is not in compliance with state law, okay? You want to make sure that you understand the laws of your state when it pertains to drug testing. In many states, there's two portions of the state statute that deal with drug testing. One is what it makes it a legal drug test. What ramifications and requirements does the employer have to provide to the claimant to make sure that they understand this is going to be a drug testing environment. One of the more common ones that we see that trip people up is the state may require the employer to tell the employee they have the right to a confirmatory test. Okay, basically the split sample test that you have to notify them that they have that right. Oftentimes we see employers in those particular states get caught up in that because they did not follow that particular part of the law. Sometimes the employer just fails to follow their own protocol. Maybe the mistakes happen, and oftentimes things don't fall between the cracks. A common error that we see in that is in post-accident testing, the individual is not tested immediately. Okay, they don't, for some reason there's a time lag or whatever there is in the testing process, and that it falls through the cracks and they don't get them tested in a timely manner. This is more of an error on the part of your service providers. For those of you who are using drug testing, there's an error in the chain of custody. Something has gone wrong in that process, and the chain of custody has been broken at some point, and then that establishes, or you lose the establishment that the testing sample was not contaminated in some way, shape, or form. And then probably the single biggest thing that trips people up in this is the individual's just never tested. A lot of times they'll go to the individual and they'll say, hey, we think you're under the influence. We want you to take a test. And the individual says, oh, yeah, you're right. I've been drinking all night before I came to work. And they take that as an admission, and they stop right there. Well, remember, the claimant goes down to the unemployment office and they develop very convenient amnesia. They suddenly never said that. They never said that in any way, shape, or form. They weren't drinking. They don't even drink. So what the test does, even if they admit it, the test removes any form of excuse or deniability that they can possibly present to prevent them, to prevent a disqualification. So even if they admit it, go ahead and document the admission, but make sure you still test them. That's going to close the book on it once and for all. Now, post-accident testing, that's one of the most common ones. And does your policy clearly state that this isn't a requirement? Okay, so that is one of the things you must make sure in most states that you have to clearly identify that, as I said previously. What is your procedure? Follow your procedure. Make sure that it is very clear. Another problem we see often, especially in post-accident testing, where we have a strong suspicion that the individual is under the influence, is that they make the mistake of allowing the individual to drive themselves to the testing site. Well, that presents a couple of different problems, and one is that gives the individual the opportunity to come up with a fake sample, dilute their urine, whatever it might be. But it also presents a problem of, well, if you thought he was under the influence, why'd you let him drive? Okay, so it's things like that. Remember, the unemployment people don't always look at this with common sense. They're looking at this, and some of them look at it with just the pure vision of clearing everybody they possibly can. So don't give them an out. Make sure you follow your procedures and protocols. Is there a regulation or law to add to the enforcement of this particular type of policy? Some states, the requirement is all for workers' comp that you must be tested. I mean, that might be common in every one. I'm not a work comp expert, but go ahead and in your policies and in your discussions with the employees about these things, use any regulatory or legal avenue that you can to reinforce the need for testing. Again, if having a good policy is one thing, but having a good policy backed up by legal standing is even more powerful. Okay. Do you provide them? Do you give them the opportunity to enter into an employee assistance program, or do you discharge them? Keep in mind your past practices. If you start down one path, you're going to run into a consistency issue if you deviate. Okay. You want to try to stay as fair and consistent as you possibly can. Not everything is always, apples to apples, I understand. But again, we're talking about not allowing them to have an angle to attack your case. So remain consistent and remain fair in how you've handled it in the past versus how you're going to handle the current situation. Then reasonable suspicion, okay? It still must be covered under your policy. It can be pretty broad. It can be pretty, it doesn't have to be outlined in every reason why you're going to test that person or why you're going to have reasonable suspicion of that person. But it does have to mention, excuse me, that you're going to have the right to test the person if you believe they're under the influence of a controlled substance. In most states, I would argue that easily well more than 4/5 of the states in the union, the threshold for having reasonable suspicion is very low. Obviously, most of the time you're basing your reasonable suspicion on the behavior of the individual in the workplace, impaired motor skills, slurred speech, whatever. So what you want to do, though, is to help substantiate the need for testing under this environment is to document everything that is unusual about their behavior. Don't leave any stone unturned. You want to make sure that it's always best if you can also include how the behavior is varying from their normal behavior. How, if you have an individual who is normally very good with their hands and has no problems, but they're sitting there dropping everything and stumbling around and everything, that's something that you want to maybe document. Again, you're only looking to do this because you're trying to help eliminate excuses. You're going to have pretty much good enough reason to test them. What you're looking for is down the road when the individual develops that amnesia and they start denying everything. This is what you're going to be able to present as evidence in supporting the reason why you had to test that person. In the cases of alcohol, okay, don't be afraid to call the police. Have them come and administer the breath test. If you need to still take them and send them down to a more formal breath test or a confirmatory test, you can always do that. But a good starting place is to call your local police department. Say, hey, I've got an employee here who's driven to work. He's obviously intoxicated. Can you come up and do a breathalyzer on him? Most of the time, the police are going to be perfectly willing to do that. I'm sure that there's certain circumstances where they won't, and then you'll have to take the more natural route, the normal route. But don't be afraid to call the police. What that then does is it establishes another legal standing that you have, is that the police department became involved and that they are looking into the issue as a legal topic. Okay. Again, as I mentioned earlier, do not accept an admission as guilt. Okay. As proof of their guilt. Okay, test them. Do not just stop there. When we lose for one of two reasons. Either we can't prove that the sample was handled in the appropriate manner, or we can't prove they were under the influence. If you don't have the drug test result, and going into it they're going to change their story, the only way you're going to have to substantiate your case is to have the drug test results. Okay. And of course, if they refuse to take the test, make sure you document that. And as I said in the opening slides, make sure that you absolutely 100% make it clear to them that if they refuse your reasonable request to take a drug test, this will result in their termination. Okay, so make sure that you document that and that they understand that very clearly, especially if you're doing a termination agreement, some kind of termination document. Now, random testing is almost always tied to some kind of legal requirement. Not necessarily, but it is almost always. For example, Department of Transportation. It might be some other form of legal requirement. A collective bargaining agreement. There was a question in the earlier in the presentation that I read. Could it be part of a bargaining agreement? Yes. Union bargaining agreements often have some form of random drug testing in it, especially in a manufacturing environment or some kind of environment where construction is a very good example, which is tying into DOT oftentimes. But you don't have to be DOT certified in order for it to be randomly tested if collective bargaining agreement or your policy says that you can do it. Now, in a lot of ways, this has been one of the areas that's been under attack for a few years as to whether or not random testing is really an allowable practice. I believe, if I read correctly, a couple years ago, California was challenging that severely. Most states, it's still your right to randomly drug test, but it's more difficult than reasonable suspicion because you have to tie the random test usually to some kind of legal requirement. Okay, you can't just say, if you're running a fast food restaurant, you can't really just say, I'm going to randomly test everybody. Okay, that one's going to have a little bit more difficult time passing muster if you have that type of policy. Now, again, it goes back to the previous two. Make sure your policy is clear. Make sure there's no ambiguity in it. Okay, this is how the testing is going to be conducted. This is how the samples are going to be conducted. This is how the people are going to be selected. Okay, so because one of the problems we see in random testing from time to time is the legitimacy of the randomness of the test is challenged. How come it is that I got tested 3 times in 9 months when Joe over there has never been tested in 12 years? Okay, so just keep sure that you understand what the requirements are. And then, of course, as always, make sure that you understand the legal requirements if you have to offer a confirmatory test. And that applies to any of these that we're talking about. Make sure that you understand the laws and make sure your policies are clearly defined and in accordance with the law. And as always, follow your procedures to the letter. Random testing is particularly sensitive to this because of just the unique nature of it. You're talking about, by just its name, it's supposed to be, these individuals are supposed to be selected through chance, not because you have a suspicion of them. If you have reasonable suspicion, it's better for you to build that case and then try to come and talk to them and get them to test on that basis too. But again, your collective bargaining agreement, if that's one of the things you're under, that's probably going to be a completely separate issue, a completely different topic under the collective bargaining thing. So you'll have probably a different criteria to meet if you're trying to test in that environment. I believe that's pretty much everything we have. I'm going to go ahead and take questions. There's a couple that I see here written down, so I'm going to scroll back up through. So yes, Marie, your drug testing, that would be perfectly acceptable since your collective bargaining agreement calls out for the random testing. So you wouldn't have any problem with that whatsoever. Just make sure that you follow your policy. As I mentioned earlier, the test about whether or not random is, that gets really sketchy, and that's one of the areas that's being challenged specifically for employers who cannot establish a specific legal requirement to randomly test. It's easy for people who are in Department of Transportation environments because the DOT regs, I believe, explicitly require random testing, okay? Or at least explicitly give you the right to randomly test. You want to make sure that you kind of do your research and think through exactly what it is you're why you want random testing, and can I really justify it if I'm being challenged outside in the core law. The unemployment people don't usually get too deep into that type of thing. They're looking at strictly whether there's a policy, and then what we're trying to do is reinforce the need for the policy by some other regulatory requirement. But your biggest problem when it comes to random testing is going to fall under other areas of labor law, and whether or not that there's a justification for having that policy in place. The another example that often comes up is that we've seen over the course of the years is somebody finds a controlled substance in the workplace, but they can't pin it on who it belongs to. So one of the frequent questions is, can I test everybody on the shift? That really kind of, there's been some legal wrangling over that as well, as whether or not you can really go out and do that. And a lot of states, you're still getting away with that, but in some of the states that are a little bit more progressive, that's being challenged as well, because again, it's an assumption of guilt issue in a lot of ways, because you're taking a collective body and you're trying to pin something on them. And of course, these things have unintended consequences. You almost always go into that type of environment and you say, I suspect Joe Smith, but Betty Smith is the one who ends up being popped, and you didn't have any suspicion of her whatsoever. So those things have unintended consequences. You might get an unpleasant surprise if you attempt to take that angle. But we have seen it done, and we've seen it done successfully as well. Well, if there's any other questions, we'll give it just another minute to see if anybody wants to type one out. And we appreciate your participation as always, and everybody who's registered will receive a copy of this, and you're welcome to use that internally. And make sure that you are, let's see, there's one last question. We have a zero tolerance policy, so we terminate for a positive test result. They have a medical card, that would they still be eligible? I'm assuming you're referring to legal marijuana, medicinal marijuana. No, they don't have the right. That's one of the kind of the grayer areas thanks to that law. But in most states, if your policy says that you can't be under the influence, then at work, then you're going to have a good chance of proving misconduct. Colorado, sorry, is a perfect example of that. To my knowledge, since Colorado instituted legalized recreational marijuana, we have never lost a drug testing case in Colorado, because the Colorado law still allows the employer to dictate whether or not that individual can or cannot be under the influence of marijuana while at work. And of course, you want always to try to tie any type of activity or behavior, job duty, I should say, to that type of reasoning, because again, you can, regardless of the environment that you're in, you can come up with a reasonable explanation as to why you can't have an individual under the influence of marijuana. So, all right, any other questions? Well, great. Hey, I appreciate your participation, and we'll be sending out the recordings here soon, and we hope that you all have a great 4th of July and enjoy hopefully it's great weather. So have a good one, and we'll talk to you soon.